Hello, and welcome to your third FAST class. This FAST class is going to be focusing on Chapter 3 of the textbook, and that is corrections and the law. All right, so it's no secret that when you start looking at things like the criminal justice system, laws are going to have effect, right? And one of the places that laws, specifically amendments, and we're going to talk about the ones that apply, have an impact is with corrections. And that's going to apply across community corrections like probation and parole, and also institutional corrections, so that's jails and prisons. So we'll start off easily. The First Amendment that we're going to talk about is the First Amendment. It is the right, of course, I'm sure you know, but it is the right to freedom of religion, freedom of speech, the right to assemble. The first piece we're going to talk about is religion. This doesn't necessarily apply to the community correction side of things, but when it comes to religion, there are some factors that come into play when you're looking in an institutional setting. Okay, so for example, if you are out in the world like you or I, or somebody who is on community correction supervision, you can practice whatever religion you want. You can have whatever materials you need to conduct your religion. You can pray anytime you want. You can have everything that you need. So if you are Christian, you probably want to have your communion and your Bible, just like other religions would like to have their sacred items to practice, right? So there are two very important federal laws that address the religious freedoms and rights when it comes to correctional clients. The first one is Religious Freedom Restoration Act, and the second one is Religious Land Use and Institutionalized Persons Act. In Cooper versus Pate, which is a 1964 Supreme Court case, the court held that inmates were permitted to practice their religion as long as three separate conditions were met. The first one is that the religion must be an established religion. And what that means is that it cannot be a religion that the inmate just made up, right? It has to be something that is practiced commonly in the world outside of the institution. So they can't just come up with a new religion. It has to be established. Second, the inmate's religious practices must conform to the tenets of the religion. Okay, so that means if, just for example, if I'm an inmate and I'm a Christian, I can't throw a fit about not getting kosher meals. Do you understand what I'm saying? There's the behaviors that an inmate exhibits and the requests that they make must fall into line with the religion that they adhere to. They can't just have off-the-wall requests and claim it to their religion, okay? And then the third is that the religious practices must not pose a security risk or disrupt prison operations. So this can be something that means, if a religion needs knives or, anything that's going to cause an institutional concern for safety, they're not going to be allowed to have it. If they, certain religions need to pray at certain times during the day, prisons will do their best to accommodate this. But security and safety of the institutions and those within it is going to come before making sure inmates get to pray at the right time, if that makes sense. Now, fairly enough, they really do try to make sure that everybody's religious needs are met. They do have kosher meals. They do have vegetarian options. They do have areas that are specific for prayer. For different religions, and they're very good about making sure that everybody is safe and gets to practice their religion well. So, with religion covered, we can move on to another piece of the First Amendment, and that has to do with free speech. And something that we're going to lump in with free speech is also the right to receive mail and email and the privacy of that. So, the goal of an institution is to preserve order and discipline, right? So they want to make sure that everybody inside stays safe. They want to make sure that people are not getting into trouble. And one of the ways that they can monitor things that are going on either within the institution or between someone who's inside the institution and somebody who's outside the institution is to monitor their mail, physical mail like letters, email, and phone calls. And as a free person, you and I would think, no, nobody is allowed to go through my mail. That's a federal offense. They would go to prison if somebody just came up to your mailbox and started rifling through your mail, right? Well, it's different in prison. Your First Amendment right as an inmate is diminished. You don't have the same rights. You have some rights, but not the exact same rights as somebody who is not in an institution. And the reasons that they will look through an inmate's mail, right, to restrict mail or check it are one of three main reasons. And the first one is to preserve order and discipline. So if there are rumors of a riot that's going to happen, and they can find that out through phone calls or mail or email. Yeah. Second, we're going to maintain institutional security. Okay, so basically what that means is we're going to make sure that nothing is coming into the institution that could harm another prisoner or harm prison staff. Okay, so that means no weapons are coming in, sneaked in through books, drugs aren't coming in through the donated library books, letters aren't containing different types of drug materials and things like that. And then the last thing that they're going to do is keep mail and check mail to rehabilitate the prisoner. So if you have somebody who the prisoner is not supposed to be in contact with and they're continually writing the prisoner, the prison can choose to take that mail and save it for another time. They won't destroy it, but they'll save it for when the inmate is released, when the inmate is in a better place emotionally or, mentally, and they will give it to them then. So the last part that we're going to talk about for the First Amendment is also the right of free association, right? Like your right to gather and protest, which is something that's hot right now, but we're going to focus on the institutional aspect of it. And also there's a community corrections aspect here too. So sometimes, we'll talk about community corrections first. Sometimes when you are put on community supervision, either probation or parole, you are given restrictions. And we're going to talk a lot more about restrictions as we move through those chapters later on. But oftentimes one of the restrictions that you get is to stay away from known criminals. And these people may be some of your close friends, right? So therefore, your criminal sentence is restricting your First Amendment right to hang out with these people. If you are convicted of drunk driving, they may also restrict you from going to certain restaurants or bars. That again is a restriction on your First Amendment right. And that's something you accept as a punishment. So turning more towards the institutional corrections side, something that has come into play recently is free association and visitation. Okay, so inmates do not have a right to visitation. Unfortunately, that is something that is a privilege. It can be taken away from inmates. And of course, right now, at least Kentucky Department of Corrections is not allowing anybody into the institutions. So there is no physical visitation going on in Kentucky right now. Now, they do have virtual visitations, which is kind of like what we're doing now. I'm talking to you through the camera, except it would be live and you would be talking back to me. And they do have those, but they do not always have physical visitation. But generally, inmates who don't cause trouble, who are known to have good visitors, and the visitors don't cause issues, they will have visitation. But because they can have that taken away, it is a restriction on their First Amendment right. All right, next we're going to talk about the Fourth Amendment. And the Fourth Amendment generally is known as the Police Amendment because it's typically focusing on searches and seizures and the lawfulness of those searches and seizures. But, The Fourth Amendment has a good amount of applicability to the correctional system in both community corrections and in institutional corrections. When you enter an agreement to be under community supervision, you sign a right to be able to be searched at any time. You know, when you go visit your probation or parole officer, you have to be willing to give biological samples, so urine samples, for drug analysis. Your probation or parole officer can come and look at your house and, basically search you, and they don't have to have a warrant or anything like that. And now the same thing goes for institutional corrections. So you have a diminished right to privacy when you're in a prison. There really is no privacy unless you're in solitary confinement, which is a place that you do not want to be. So while you do have your own little, it's kind of like a filing cabinet, but without the drawers. So you open it up and you can have all your belongings in there. Those are liable to be searched at any time that they think that you might be hiding something. They can seize materials that aren't supposed to be there. They don't need any kind of warrant. They can just take them if they determine them to be a danger or against institutional rules. So you have a diminished Fourth Amendment rights when you are a correctional client. Okay, so the Fifth and the 14th Amendments are the next ones that we're going to talk about. Those focus on due process. And due process means that all laws and all criminal procedures are reasonable and applied in an equal and fair manner. Okay, so this means that, we are making sure that the laws themselves make sense. They're reasonable. We wouldn't say that, okay, you ran a stoplight, that's 5 years in prison, right? That's not reasonable. But we would say, okay, you ran the red light, but you were also drunk and you hit another car and injured them severely. A 2 or 3 year prison stay for that seems more reasonable, right? The second part of due process is making sure that that punishment, the 2 to 3 years in prison for that situation, is applied equally across gender, race, sexuality, anything that you can think of. So if we have a black man who does that, right, and they will generally be charged with something harsher because our justice system is biased. So you may have a black man who does that and they get 7 years, and then you have a white man who does it and he only gets the 2 to 3. Right, that's not being fair. That's not putting forth that criminal punishment in a fair and equal manner. That was kind of an extreme example, but I want you to get what's going on behind the due process, right? So it has to be reasonable and it has to be used in a fair and equal manner. So the Fifth and the 14th Amendments apply to corrections. The Supreme Court has ruled on a bunch of cases surrounding the Fifth and 14th Amendments. And they have found in most, but not all cases, that the court has held to restrict due process rights or to deny that a due process claim exists in the first place. Okay, so when it comes to being an inmate or someone under correctional supervision, you do have some restricted Fifth and 14th Amendment rights, okay? That's not necessarily fair, but it's just where it comes into play most, and you will read through them in your textbook, is there are things about we want to move this inmate to solitary confinement because they attacked another inmate. Okay, well, we don't have time to go through every single process, get a judge's okay, get the warden's okay to do this, to move this person into this more restrictive housing. We're going to do it, and then we're going to fill out the paperwork because we need to remove the immediate threat of that inmate attacking somebody else. Okay, so it's basically streamlined in the correctional system. Due process is streamlined. The next amendment we're going to talk about is the 8th Amendment. The 8th Amendment holds that correctional clients cannot be held in a cruel and unusual punishment, right? So we can punish them, that's why they're in prison, but we don't want the negative effects of prison to be so much that they are considered to be cruel and unusual. Okay, and so the way that we measure this comes from a Supreme Court case, PUGH versus Locke, 1976. You will read about it, or you've already read about it. But this Supreme Court case came out and established what is called a totality of conditions test. So the totality of conditions test looks at all of the factors of the prison environment that any inmate is going through. And if those conditions meet a certain level, then they are considered to be cruel and unusual, and the prison needs to do something to reduce those conditions so that they are not cruel and unusual. Excuse me. The next case that deals with the Eighth Amendment is Estelle versus Gamble, and that's 1976. And Estelle versus Gamble established what is called the deliberate indifference standard. And what this applies to is healthcare. So this is if any prison staff member sees that an inmate needs medical care, or if an inmate asks for medical care and the staff member is indifferent or they don't take it seriously, that can constitute cruel and unusual punishment. It's called deliberate indifference because obviously the staff member has been informed and they're choosing to not do anything about the inmate's medical condition or pain. So that can constitute cruel and unusual punishment. What does not constitute cruel and unusual punishment is capital punishment, which is also known as the death penalty. There were issues with the death penalty in the 1960s and due process, and we're going to talk supremely in depth about that when we get into the capital punishment chapter. But basically what had happened is there were a lot of issues with due process, and that the death penalty was not being given out fairly across populations. So they actually stopped doing the death penalty in the 60s, the 1960s, and held off putting people to death until the mid-70s. And in the mid-70s, there was a Supreme Court case called Gregg v. Georgia. Gregg v. Georgia put forth new precedents for sentencing people to the death penalty in order to address all of the due process issues that were happening before. So Gregg v. Georgia resulted in 3 separate procedural changes. Okay, so the first one is called bifurcated trials. Okay, so that just means that the trial is split into 2. So the first part of the trial determines guilt or innocence. Okay, if they're found guilty, they move on to the second part of the trial, which is going to determine whether or not they get the death penalty. Second, there's automatic appellate reviews. So this means anytime somebody is sentenced to the death penalty, it's automatically appealed. There's automatically going to be an appeal process so that everybody can be double checked. They can say, yes, for certain, we know that this person is guilty, we know we're going to sentence them to death. And then the last procedural thing that Gregg v. Georgia brought through was the proportionality review. And the proportionality review is basically kind of what we talked about earlier with the red light and running the red light. They're going to look at the crime, they're going to look at the circumstances of the crime, and they're going to determine if the death penalty is truly the only punishment that is fit for the crime. Okay? So the overall is that capital punishment is not cruel and unusual. However, we cannot administer capital punishment to children. We have determined that putting developmentally disabled individuals through capital punishment is cruel and unusual punishment. So those are the key amendments that are talked about in Chapter 3. This has been your 3rd FAST class. I'll upload the 4th FAST class soon. I hope you guys are staying safe, and I look forward to seeing you in class. Bye.